a new book by Eric Foner, who, of course, is a leading historian and expert on the Civil War and Reconstruction periods. Professor Foner retired from teaching a year or two ago after several decades, I think about a half a century, really, of teaching at Columbia University, and a voluminous amount of scholarship that includes the writing and editing of more than 24 works. His study of Lincoln and American slavery, The Fiery Trial, published in 2010, won the Pulitzer, Bancroft, and Lincoln Prizes. And he hasn't stopped writing. His new book, The Second Founding, focuses on the 3 constitutional amendments enacted in the wake of the Civil War. The 13th abolished slavery. The 14th constitutionalized the principle of birthright citizenship and equality before the law. And the 15th aimed to secure black male suffrage. Significantly, too, by charging the federal government, not the states, with enforcement, these measures sought to transfer authority to define the rights of citizens from the states to the nation. Alas, however profound and pivotal this remaking of the Constitution was to establish the principle of equality, it was subsequently undermined by Supreme Court decisions and state actions. The Jim Crow system followed, and only decades later, well into the 20th century, did the U.S. make renewed strides toward realizing the concepts of racial equality, due process, and individual rights reflected in the Reconstruction Amendments, although we still have very far to go as a country. Again today, as we all know, there are fresh political challenges to birthright citizenship, voting rights, due process, and equal protection under the law, which makes Professor Foner's book especially relevant and key to understanding properly the history and meaning of the Reconstruction Amendments. Now, as an added attraction this evening, Professor Foner will be in conversation with Eric Holder, who served as U.S. Attorney General from the start of the Obama administration in 2009 to 2015 and was the first African American to hold that position. You can speak with firsthand experience and authority about how the issues raised in Professor Foner's book are playing out today. In these days, Mr. Holder spends a lot of his time leading a national effort to undo gerrymandering. And moderating this discussion will be Jamelle Bouie, a talented journalist who was chief political correspondent for Slate before, at the start of this year, becoming the newest and youngest columnist for the New York Times. He's also a political analyst for CBS News. So please join me in welcoming our 3 accomplished guests. Thank you.
Let's set the timer. There we go. Thank you all for coming. Sorry, they have like handheld mics, and I have this lav here. I'm going to not shout at you. All right. Okay. Thank you all for coming. I think this will be a really fascinating conversation, and I think we're just going to get started. So, Eric, yes? You've spent much of your career studying Reconstruction, this period of our nation's history. What inspired this particular treatment, this focus on the Reconstruction Amendments?
Right. Well, I have written a lot about Reconstruction. The amendments have come up now and then. But, I should say I'm not a lawyer. I'm not a law professor, but I do. Some of my friends are lawyers. Oh, sorry. Is this on? All right, sorry. Basically, I have learned that very few people know very much about the 13th, 14th, and 15th. They don't know much about Reconstruction, and they don't know much about these amendments, which I think are critical in our legal and political and social history. And the people who were involved in creating these Reconstruction constitutional amendments, James Ashley, John Bingham, and others, are not exactly household names. Most Americans, if you ask them, what are the key documents of our history, will say the Bill of Rights or the Emancipation Proclamation. They probably won't mention the 13th, 14th, and 15th Amendments. So, to some extent, I'm just trying to, our job as historians to try to educate people about things they don't know as much about as perhaps they should. But also, as I was saying, I'm not a lawyer, but I speak a lot at law schools. And I discovered that even at law schools, there's a lot of misconception, I think, as a historian, about where these amendments came from, what they were trying to accomplish, and that, I think, seeps into the law and into judicial decisions. And, I kind of came to the conclusion that a lot of our jurisprudence based on these amendments, which is, very important jurisprudence, is kind of misconceived in a way, or takes a far too narrow view of what these were trying to accomplish. So all of those things kind of, usually when I write a book, it's because I'm dissatisfied with what's out there. And, people get annoyed, but I try to correct what they are thinking.
Eric, you are a lawyer. You were a very prominent lawyer for some time. What is your... I mean,
At one time, I'm still breathing, still here.
Exceptionally prominent. What is your experience and background with thinking about these amendments, but sort of looking at these amendments in the context of your work?
It's interesting because just for context here, I think of this work and these amendments in two ways. One that I'll answer as a lawyer, but also I was a student of Professor Foner's at Columbia, and the most, I think, influential classes that I took were the ones that he taught while I was there. That was in the late 1990s. That was a joke. And so I think of the young public school student who came from a good school, in New York, and had this vision or this, had been taught what Reconstruction was all about, only to be faced with this then young professor who really said, that's not the way Reconstruction was. It was not a failure. It was not, as it was shown in Birth of a Nation, And so I think of it that way. But as a lawyer, 13th, 14th, and 15th Amendments are extremely important because not only of the historical context, but because of the contemporary resonance that they have. You can trace back, questions that we are grappling with today. Voting rights, mass incarceration. These things don't necessarily have their roots in these amendments, but what we're dealing with today, I think, certainly was impacted by the way in which, I think as Professor Foner correctly points out, the way in which the Supreme Court interpreted the amendments. And then, those early decisions that I tend to disagree with because of precedent, stare decisis, this notion of, always looking back, that's kind of the foundation for the way in which these amendments are looked at even today. As I said, I think some of these opinions are glaringly wrong, I'm not sure, but they are, having never been overruled, controlled.
So one thing that fascinates me about the book, Eric, is that you really take the term, you talk about Reconstruction and kind of just throw the term out there, but you very much take the term seriously, that what the people drafting the amendments were doing was constructing new notions of what it even meant to be an American in the wake of this really devastating war, in the wake of an ongoing civil conflict in the South. Lawmakers were trying to figure out what did American citizenship even mean anymore. And so I would love for you to talk a little bit about that journey for those lawmakers? What kinds of questions were they asking themselves? What kind of debates were they themselves tuned into? Because there's a whole world of conversation and argument and debate happening in the country as they're doing their work in Congress.
Right. Well, first of all, one of the things that struck me as I was looking into this is how much of the conceptualization that goes into the really what I would call the rewriting of the Constitution in Reconstruction comes out of the anti-slavery movement. You have to see it. Before the Civil War, citizenship was poorly defined, and the Supreme Court ruled that black people could never be citizens. Citizenship of the United States was only for whites, according to the Supreme Court of the United States. But there was this alternative vision in the anti-slavery movement of a national citizenship which superseded race or other distinctions, and in which all citizens were treated equally before the law, which didn't exist anywhere in the United States when it came to African Americans before the Civil War. And then, of course, the Civil War gives a tremendous impetus to that egalitarian outlook. But I think, the question, absolutely, it's amazing. I won't say anything about the standard of debate in Congress nowadays, but if you read the congressional debates, you have to be impressed with the seriousness with which people in 1865, 66, 67, 68 talked about fundamental questions: democracy, equality, what is that exactly? Citizenship, who should be a citizen? What are the relative powers of the federal government and the state governments? They debated the Reconstruction is important because the fundamentals of our country, of our system, were up for grabs. And nobody quite knew how it was going to turn out. I mean, in the book, I use a term which is not of that era, but to describe what's happening: regime change. They're trying to change a pro-slavery regime from before the Civil War into a post-slavery or anti-slavery regime. How do you do that? And so, I think as the question suggests, there were serious, profound debates which are really still interesting to look at, given that so many of these issues are on our agenda today.
Do you have any thoughts on today?
No, I think the point that I keep calling him Professor Foner, so that's how I know him. But I think that the point there is a really important one, that the nation that existed before the Civil War was not destroyed, but we have a fundamentally different nation after the Civil War, and I think these amendments are attempts to guide the construction of this new nation. I think it's if you look at, certainly if you read the book and what I was taught, there was an optimistic view of the nation that could be, and you certainly saw that in Congress. You certainly see that in some of the debates in, contemporary newspapers and things like that. But the Supreme Court kind of comes in, and, lawyers are conservative. I don't mean political, but their lawyers are kind of conservative people, and they were status quo oriented, and they really cut back on that notion. They were not ready for the change that I think these amendments reflected, and that I think the war brought about.
Maybe I could just add one point. Is one of the things that I argue strongly in this book is that one has to go beyond to find out what they were trying to accomplish. One has to go beyond the traditional sites of lawmaking, the Congress, the courts. These issues are being debated up and down in the society at this time, and I was once, a few years ago, at a federal judicial conference giving a talk, and Justice Sotomayor was there and fielded questions from a whole audience of judges and lawyers. And I asked her, she was the first person ever to cite Du Bois's Souls of Black Folk in a judicial opinion at the Supreme Court. And I asked her, why did you do that? That's not a legal document or something. She said, well, I think judges need to get out more and find out what's really going on in the society. And that happened in Reconstruction. I mean, that is to say that people in their homes, in their workplaces, in their political gatherings, black, white, north, south, were debating these questions. And so to understand these amendments, you've got to go beyond Congress, even though it's so important, and look at what people in the whole society thought these constitutional amendments were trying to accomplish.
And it's interesting because I think that's an interesting point. So if you're looking back at these amendments and you are on the Supreme Court now and you are an originalist, well, what is it that you're actually looking at? If you look only at that which they were talking about in Congress, I don't think that really gives you a good sense of what was going on in the society at that time. And you're missing really relevant things, really relevant discussion that helps you to understand what was intended by the authors of these amendments.
Exactly. And one of the consequences of just looking at Congress is you lose any kind of black voice in this debate. There were no black members of Congress when the 13th Amendment was passed. There were no black members of Congress when the 14th Amendment was passed. And yet African Americans were active in these debates. And in fact, the 14th Amendment was only ratified because by the time it went to the states, you had new governments in the South elected by both black and white men, and they ratified. Without black suffrage, no 14th Amendment. And yet you rarely get a consideration of what African Americans thought they were doing when you get discussions of the intention of these amendments.
An interesting thing you bring up in the book is that prior to the Civil War, black abolitionists, black activists, when they talked about the founding documents, they talked about the Declaration. The Declaration here is the lodestar for American ideals, but it's after the Reconstruction Amendments that African American activists start saying, no, the Declaration and the Constitution, that for them at least, these amendments fundamentally reshaped what the Constitution was and made it like a genuine freedom document. One sort of interesting part of the book is you kind of looking at, basically, these amendments had kind of radical implications when people started really thinking about them. And part of the debate was, to some regards, assuring people that the implications wouldn't be as radical as they might be. So for the 15th Amendment, one question was, well, does this enfranchise women? Does it enfranchise Chinese Americans? Because, the language, that's where the logic goes. And so this idea of contained, even within a narrow reading, are still these very expansive implications, I think is a really important and point I love to talk about.
Yeah, well, that's a very good point. All these amendments were compromises in one way or another, and all of them were bitterly attacked by Democrats, which was the white supremacist party at that time. And to attack them, they raised all these implications. No, these will give women the right to vote. We don't want that. Or the 13th Amendment banning slavery and involuntary servitude means men will now have to pay their wives for their work in the household. Maybe that's not a bad idea, but that wasn't what was on the minds of the members of Congress. And therefore you get a funny thing in that the radical implications are put forward by the opponents, and those defending the amendment say, no, it's not meant to do that. It's not meant to do that. Although the main point is that the language is open to many interpretations. This is why the idea that there's a single original intent is absurd intellectually, although some jurists seem to believe in it. The language is intentionally vague. It's the language of general principles, and everybody knew they would have to be worked out and implemented over time, and there were many possible ways of doing that. Well, so the 15th Amendment says that states cannot deny any male citizen the right to vote because of race. Well, any citizen the right to vote because of race, but it seemed like they could still deny women the right to vote, and yet many women try to vote because of it. Susan B. Anthony actually did vote in the 1872 election and was then arrested for voting. So people were constantly trying to push these amendments, stretch them, push them to their radical implications. And of course, the Supreme Court comes in and then starts the process of narrowing until by the turn of the century, they've been largely eviscerated, even though they're still in the Constitution.
And we were talking backstage, this is the point you made, that the 13th Amendment has this enforcement clause, which seems to carry, I mean, it's not really the basis for any jurisprudence, but the language seems to push you towards being able to do much more with that amendment in terms of addressing the legacy of slavery than would appear at first glance.
Yeah, I mean, I think that's right. If you look at the amendments, they all have an enforcement provision that says Congress will be able to enact laws. And I view these amendments as kind of declarations of where we are. Again, I think in a more optimistic way than was interpreted by the courts, a more expansive way than was interpreted by the courts. But clearly, it seems to me, the authors of these amendments expected that on the basis of the existence of the amendments and those enforcement provisions, that more would be done in this regard. And that was not the way in which the Supreme Court viewed it.
What are some of the ways in which the court curtailed the possibility of the amendments?
I don't want to go into a long disquisition on different Supreme Court decisions, but just in a nutshell, first of all, they pretty much said that the 13th Amendment is now finished with. Chattel slavery no longer exists, and that's it. The purpose of the 13th Amendment has been accomplished. And this possibility that you mentioned of using the 13th Amendment to attack what are called the badges of slavery, the incidents of slavery. Slavery was a total institution. It was a system of labor, a system of politics, of race relations. Abolishing slavery could mean attacking all those other elements of slavery, particularly racial inequality, which is the direct legacy of slavery. But the court said, no, people are just using slavery too broadly here. And, very rarely, there's almost no jurisprudence based on the 13th Amendment. There was a 1968 case about, upholding the open housing law, where they said, well, housing discrimination is a badge of slavery. But that's it. It has never gone anywhere. 14th Amendment, they adopted what they call the state action clause, that the 14th Amendment protections only apply to violations by the government, by the state governments. In other words, private act, violence, Ku Klux Klan attacks, people murdering people to prevent them from voting. There's nothing the federal government can do about that because it's by private individuals, not state action. And that's still good law. The Supreme Court, not that long ago, has cited some of these, as Attorney General Holder mentioned, these are still precedents that are out there and are cited by the Supreme Court. The state action doctrine, I think, is a very pernicious thing because it allows the court to, any sort of private discrimination doesn't trigger federal intervention on the basis of the 14th Amendment. And the 15th Amendment, African American male voting, the courts eventually said, look, unless the states say we're denying black people the right to vote, there's nothing the federal government can do. And when they did take the right to vote away in the late 19th, early 20th century, it was through laws which didn't mention race, but were all applied in a purely racist manner. Laws like poll taxes, literacy tests, understanding clauses, proving you understand part of the state constitution. And when, that was challenged by Giles v. Harris, Williams v. Mississippi, others, the court said, look, the law doesn't say anything about race. We can't go in and find out how it's being implemented, and so even though the vast majority of black men lost the right to vote in the South, the Supreme Court just threw up its hands and said there's nothing that can be done about this. So, in all these cases and many others, they limited. My argument at the end of this book is there is a lot of latent power still in the 13th, 14th, and 15th Amendments that has never been utilized, particularly in the area of racial inequality, racial justice. And maybe a different Supreme Court down the road will be able to go back and rethink this and invigorate these amendments in ways they haven't been used.
Yeah, I think it's interesting that, you look at the 1964 Civil Rights Act, as you mentioned in the book. I mean, there you could use these amendments as the basis for the act, and yet they went with the Interstate Commerce Clause, as if the 64 Civil Rights Act was really to promote commerce within the states. That wasn't, clearly this was a race statute, and yet they did not go to
because years earlier, in the civil rights cases of 1883, they had overturned the predecessor to the civil rights law, Charles Sumner's civil rights law, which banned racial discrimination in public accommodations, theaters, restaurants, transportation. And the court said, no, that's all no good because it's private discrimination, and the federal government is not empowered. 1964, when the Supreme Court upheld the Civil Rights Act of that year, they could have said, hey, we were wrong. We were wrong back then, and obviously these discriminations are a badge of slavery, or when a state allows them, it's an action by the state demeaning other citizens. But they didn't want to do that. This is precedent is important. So they said, well, actually, the Interstate Commerce Clause allows Congress to do this. Forget about the 14th Amendment. And that makes, as you said, that makes the court look ridiculous. People were not demonstrating in the streets so that they could sell goods more effectively across state lines. That's ridiculous.
The interesting thing to me about thinking through how the Supreme Court narrowed these amendments in the 1870s and 1880s is how familiar it sounds in the present, how with Shelby County v. Holder, the court.
We just call that the Shelby County kids. It's like you wouldn't want like Dred Scott versus Holder. I mean, it's just Shelby County. I don't.
The court takes this strangely narrow view of what Congress can do to secure voting rights. And the question I have for you is, when it comes to tackling gerrymandering, which is a project you're really working on right now, do you worry that the court's propensity right now to read these things quite narrowly, do you think that might have an adverse impact on the ability to actually do something that is about securing the voting rights of American citizens?
Sure, it's going to certainly make it more difficult. I mean, we still have another legal option to go through the state courts. We won a big case in North Carolina last week, won one, I guess, about a year or so ago in Pennsylvania, but it's a slog. You've got to go through state by state, and you have to find in these state constitutions provisions that will allow for the bringing of these cases. A Supreme Court decision, an appropriate Supreme Court decision, I think, with 5-4 the other way, would have made it much easier. The federal court use the federal courts to bring these anti-gerrymandering lawsuits. But really, what really strikes me is there's a historical resonance here with the court essentially saying, we can't handle this. And the Alabama case, I'm having seen him, Giles, you had the same thing. The court back in the late 19th, right, saying the same kind of thing. This is just not something for us. We don't want to be the arbiter of all the elections in Alabama. And I see that again in some of the comments, certainly in the oral arguments, where the justices, present-day justices, talk about being concerned of being inundated with election law cases. And I remember listening to that and thinking to myself, well, if they're cognizable, that's kind of your job. Get over it.
The court has never somehow come to terms with the fact that these three amendments really change the federal system, really change the balance of power between the state governments and the national government. In the Shelby County case and other cases, they say, well, there's a federal system established in 1787, and here's what it is. But they act as if these amendments were never passed, which change fundamentally. They limit the powers of the states. They empower the federal government to, as they say, to enforce the rights that are in these amendments. And yet the Supreme Court doesn't seem to feel that the federal structure itself was altered in any way by the Reconstruction Amendments.
You guys have exhausted my questions, so now I have to go further. Sort of on that point, it does seem as if one of the legacies of these amendments is that we're still basically trying to figure out what American citizenship even really means, right? Part of the dispute about recent voting rights cases is it's two competing views, right? The voting right, that being an American citizen entitles one to voting rights that cannot be curtailed or limited in any possible way. Anything that might prove an obstacle to those rights is unacceptable, whether it's voter ID, what have you. And the other side is that, the states still have some prerogative when it comes to determining the kind of elections they want to run, and if that, conflicts with how voters can participate, well, the voters have to figure it out. And I don't have a question here. It's just sort of,
the point is exactly right. And again, that's another area that comes right out of Reconstruction. I mean, I have written a lot about Reconstruction, and one of the reasons is so many issues of Reconstruction are, like on the front page of our newspapers. Well, I shouldn't say that, because nobody reads the front page. If they read it on their phone, they're sort of like talking about record players and stuff. But I'm dating myself here. But, citizenship, voting rights, terrorism, the Klan, these are Reconstruction issues. But this is another example, even in Reconstruction, in the famous slaughterhouse cases, that's where the 14th Amendment says states cannot deprive people of the privileges or immunities of citizens. Well, what are those privileges? Maybe the right to vote. What about the right to an education? What are the privileges? Well, the Supreme Court said, actually, there aren't any. Privileges and immunities, the federal government has no power. Yeah, they listed, well, as an American citizen, you have the right to be protected on the high seas against pirates by the federal government.
It's nice to know.
But that didn't affect the lives of most former slaves that much. Or the right to go to Washington to petition the government. But all your other rights come from the states, still, despite the Civil War, and therefore the federal government has no authority over. Instead of saying, here are the privileges and immunities that come along with being a citizen, they basically said, forget. And that clause has been completely abandoned. It's almost never cited by anybody because of slaughterhouse. And not that long ago, Justice Alito, in a decision, said, we are not going to revisit slaughterhouse. Because the people who wrote those decisions were right there in Reconstruction, and they knew what was going on. But he doesn't notice that most Republicans and others condemned the slaughterhouse decision. Most members of Congress said these guys have got it wrong. They were there too, but that doesn't seem to be worth citing.
Privileges and immunities, yeah. If they had been, I think, if that clause had been correctly interpreted in the way it was intended, there'd be an argument you could make in present-day America to say that a privilege and immunity that an American citizen has is the right to health care, Yeah, I mean, there are a whole range of things.
Yeah.
And yet we are constrained from making those arguments by the reluctance of the court, Justice Alito and others, from re-examining a decision that I don't think was supported. Certainly, it was criticized at the time, and 100 years or so later, I think that criticism is seen to be nothing but valid. And you need a court that would have the guts, and it would take guts, to say that these opinions, 100 years or so ago, longer than that, I guess, are wrong. We're going to overrule it. It would change in a fundamental way. I mean, that would be a really legal. That would cause a legal earthquake in many ways. But I think it would be appropriate.
They don't seem to want to overturn. I mean, for some reasons that are understandable. Not long ago, as you know, the Supreme Court, I guess Justice Roberts, quote unquote, sort of overturned Korematsu, another one of the worst decisions in American history, sort of obliquely, right? In another case, he said, "Oh, by the way, Korematsu is no longer good law." That was just like an offhanded comment. So they're rather nervous about directly admitting that previous Supreme Courts have just blown it.
One of the through lines of both this conversation and the book is this idea that the Supreme Court is an obstacle, right? That we have perhaps an artificially narrowed constitution for the Supreme Court, and that this idea that the Supreme Court is a defender of liberties, of individual rights, might be mistaken.
I think that's right. We have this. I grew up during the time of the Warren Court, and so my view of the Supreme Court was formed by all the decisions that come out of the Warren Court. A lot of stuff to incorporation, the 14th Amendment, But if you look at the history of the Supreme Court in its entirety, the Warren Court era is really kind of an aberration. What happened in the interpretation of these amendments is more consistent with what's going on in the Supreme Court today than the Warren era. And some of the same arguments, the same views. There's a lot of things that sound distressingly familiar. When you read this book, and so buy it and read it. When you read this, when you look at chapter 4, which deals with kind of the legal side, the Supreme Court component. A lot of this stuff will sound very familiar. Will have a 21st century sound to it.
Yeah, unfortunately, we also hear the voice of Andrew Johnson, the president in the first part of Reconstruction nowadays.
And we have a president who's questioning whether or not this should be birthright citizenship and whether or not he has the ability by executive order to.
And Andrew Johnson said black people are not entitled to be citizens. He vetoed the Civil Rights Bill of 1866. He said he didn't use the term reverse discrimination, but he said all the benefits are given to black people here and none to white people. It's against white. So, and that kind of argument that expanding the rights of non-whites somehow takes something away from white people we hear it. No question about it today.
It's almost as if, precisely because many Americans think of the Constitution as being the Constitution of 1787. It's almost as if these amendments, in addition to transforming it, they're not like deleting that previous Constitution, introduce this fundamental tension into what that document actually does for the country. And in that idea, expanding rights takes rights from someone else. It's like a dramatization of that tension because, by some measure, looking at the Constitution before the Civil War, that might actually be the case. Like it gave prerogative to certain kinds of people.
I mean, as I said, maybe at the beginning, this nation, and after these amendments, is fundamentally changed. We go from, the Constitution, we go from the 3/5 clause to black men are black people, citizens. I mean, that's the breadth of the change, the degree of the change, and it's you look at these amendments and the changes that they wrought. This nation is fundamentally different, but did not become what I think the authors of these amendments intended. We didn't get to the place where I think they wanted us to get, that they anticipated that we would get to.
I think it's time for questions. So I have note cards.
Sorry, Riley.
So, first question here. After all your years of experience writing about the Civil War and Reconstruction, are you learning? Sorry.
Do you want to use this?
I actually do want to use that. After all your years of experience writing about the Civil War and Reconstruction, are you learning anything new or surprising from a beginning scholar, Professor Foner?
Yeah, I mean, a lot of scholarship on Reconstruction is being done right now. Much of it is extremely valuable, focusing on areas that are not necessarily in this book. Let's say the impact of the end of slavery on women, both African American and white, and how sort of you might say women's Reconstruction may have been different in some ways than how the period affected men. A lot of good work being done on that. There's an effort to, historians don't know how to count. For example, we talk a lot about the long 19th century, from the American Revolution to World War I. A century means 100 years, I think, but we don't know that. But there's now the long Reconstruction. People are pushing beyond the conventional date, 1877, to talk about the late 19th century, making the valid point that, Reconstruction didn't just end in one moment. African Americans continued to vote for a generation after that, and hold office in some places. And how, what does it mean if you look at Reconstruction as covering a much longer time period? So, and the West is being brought in. I think you mentioned Chinese, and people are now looking at the Reconstruction as a national phenomenon, how other parts of the country than the South, particularly the West, reacted to the end of the Civil War. So, yeah, historians, there's always a change in historical interpretation. There's always new works. I mean, 20 years ago or so, I wrote a comprehensive kind of history of Reconstruction. It's not the last word. There never is the last word in historical writing, but it's still the latest word. What I mean is there's a lot of things that have been done, but nobody has tried to write a full history of the period, differing, with a different perspective. So, but they will. Some misguided scholar will try to overturn my books, but yes, a lot, work is still going on in many ways, and because the present always gives historians the questions they're interested in. And these questions, as I said, are on our political agenda right now, and so they are directing more and more people back to Reconstruction to find the origins of these issues.
That's actually a chilling thing, to think that, what's going on in our contemporary experience is pushing us back to, Reconstruction 150 years or so, and then most distressingly finding out that there are similarities in court decisions, precedents.
Is there now a need for a third founding, or what features of the 1787 Constitution did radical Republicans leave unaltered that they ought to have changed? I swear I didn't write this question. Good question.
Well, the first thing, there were dozens of constitutional amendments introduced in the aftermath of the Civil War. Only 3 of them were enacted, but one that I would have liked to see passed, which was proposed, was abolishing the Electoral College. That would have been a good idea. Of course, the structure of the government remained the same in many ways, although I think, as I said, the power within the federal system was changed dramatically. Most historians, I don't know if this is a constitutional question, would say the real absence in Reconstruction was an effort to sort of uplift the former slaves in economic terms. The phrase 40 acres and a mule, which was widespread in Reconstruction, this is what African American former slaves demanded, that the government give them land as, they didn't use the word reparations, but this would be payment for their many years of unrequited labor. So one might say that the political revolution went forward, but the economic revolution stopped. The abolition of slavery was itself an economic revolution, but then trying to deal with the economic conditions of the former slaves, no real solution was put forward, and that was a serious flaw in the Reconstruction agenda. And I think we have to today, of course, the question of inequality, whether it's racial inequality or just 1% versus everybody else, is again on our agenda, and we face the same thing. The civil rights movement solved some of the political inequalities, but it left the economic inequalities still very glaring. So, that's where I would say the absence probably lies.
In some ways, I think that, I don't know how you'd characterize it, but I think the civil rights movement actually led to, I'm not sure I'd call it a third founding, but maybe 2A or something like that, where the nation is changed again. We go from a an enslaved nation to one that is free. And then we go from a nation that is, in essence, an American apartheid system to one that is on the other side. I almost think we're ready now for a fourth founding.
But the point, that's quite right. And the point, though, is they used the Reconstruction Amendments to do this, right? They didn't need, in South Africa, when they abolished apartheid, they had to write a whole new constitution. We didn't need a new constitution. There was no significant change in the constitution as a result of the civil rights movement. We needed the constitution we had to be enforced, which it hadn't been. And when you got to a point where the federal government and the courts were enforcing it, you could have this radical change. It shows you the power that you could find in the 3 Civil War amendments, but too often we haven't.
question for me. That seems a little bit like the limits, but the limits and possibility of just constitutionalism in general, right? That on one hand, the Constitution has this power, and if it's enforced, if it's read broadly, it can do very expansive things. On the other hand, it is, at the end of the day, a sheet of paper, and if a political culture decides not to enforce it, decides to leave it aside, and there's not much, I mean, you can do something about it, but that has real impact as well.
Constitutions do not solve all problems, and as you say, they are not self-enforcing. Rights in the Constitution don't enforce themselves. Somebody has to do it, whether it's Congress, courts, or something. So it fundamentally becomes a political question. Who has the political power to define what the meaning, the constitutional meaning of this language is? And too often, as Attorney General Holder said, the political power really lies in very conservative hands in our history. A lot more happened in Reconstruction than just the passage of these amendments, obviously. There was all sorts of legislation. There was violence. There was the use of troops against the Ku Klux Klan by President Grant. There were vast economic changes, although not sufficient for the needs. So, this is one important strand which runs all the way to the present, but it's not a total history of all the... It was a remarkable period because everything was up for grabs, and debated all over the society, and a remarkable experiment in interracial democracy took place in the South. So it's worth knowing about today, even though it's not the most widely known era of American history.
And this sort of gets to this next question we have, which is, could you give some perspective on why there's so much attention given to Reconstruction and the reparations conversation in this particular moment?
Well, yeah, I'm glad as a historian that people are paying attention to Reconstruction. I'm actually glad they're debating reparations, whether people think that's a good way of framing the problem or not. At least it forces people to start thinking about history, which, as a historian, I think is always to the good. But I think this has been one of the unexpected consequences of the election of 2016, that people are suddenly wondering about Reconstruction, and particularly the overthrow of Reconstruction. In the early 1890s, Frederick Douglass said something to the effect that principles that we thought had been securely obtained are being challenged and overthrown. That generation experienced that, and many people feel that we are going through a similar process today, where principles we thought were universally accepted are suddenly being attacked and overthrown. And so that has generated interest in how did that happen in the past. And so it directs people's attention back. And the lesson is, of course, that rights can be gained, but rights can also be taken away and lost. And therefore, vigilance is essential if we want to see our constitutional rights protected.
No, I think that's right. And I think what this also, I think, demonstrates is that we as a nation still have not really come to grips with race as an issue in our society. I said a while ago, back in 2009, I gave a speech where I called us a nation of cowards for not confronting that issue. Although some people tend to think I got up and said, we're a nation of cowards, and I sat down. But the speech actually is held up pretty well. I've read it. But we've not grappled with that issue. And you compare where we are now to looking at where we were during the course of the creation of these amendments. We are expert at finding ways to avoiding painful conversations and necessary action when it comes to dealing with issues of race, discrimination, subjugation. And until we get to that point, we're never going to make the progress that we need. But I think that's why, in some ways, I think this is so valuable. I was an American history major, and this is my most influential professor. But I think that unless you understand the past, the American racial past, you can't really understand the American racial present or plan for an American racial future.
So I'm out of questions here. Can I ask questions of the, directly from the audience? All right. I'm gonna right here. Speak loudly. Back in the day.
Yeah, that's a very good question. Radical Republicans in Congress wanted what they called a positive amendment, saying every male citizen 21 years of age or over has the right to vote. All right? Now, male would be in there. There was not widespread support for women's suffrage at that time. No state allowed women to vote at that time. But they wanted to universalize or homogenize the rules about voting for the whole country. That would have solved a lot of problems if that had been in the... But it wasn't, because many states wanted to keep, not only in the South, wanted to keep control of the laws of voting. California did not want Chinese immigrants to be able to vote. Rhode Island had a property qualification for immigrants, naturalized citizens who wanted to vote. So the tradition of state control of voting was very strong, and they were afraid that they couldn't get a constitutional amendment ratified unless it were restricted to African American voting, which itself was a tremendous change in the political system. Before the Civil War, only a few states in New England allowed African Americans to vote. Pennsylvania didn't, Ohio didn't, Illinois didn't. But it turned out to be an amendment with loopholes, because it seemed to allow for, literacy tests, property qualifications, you name it, as long as they were not racially described. That left a serious problem. As I said, these amendments were compromises, and to get the 3/4 of the Congress and the 2/3 of the states, or the other way around, 2/3 of Congress and 3/4 of the states, you could not do everything the radical Republicans wanted to do, unfortunately.
I'll read.
You talked about original intent in the amendments, and I want to ask you to address the Equal Protection Clause and its evolution as a wide blanket of protection, certainly beyond its original intent.
Well, I'm not a believer in... I think the whole notion of original intent is intellectually spurious. There was no one... No historian believes that any significant document has only one intent or meaning. On the other hand, as a historian, I'm interested in what these people were trying to accomplish. What did they think they were doing? You can call that original intent if you want. But the point is, there was debate all across the society. These things were passed in Congress, states. What did African Americans in Southern legislatures who voted to ratify? What did they think the purpose of these amendments was? But your point is, of course, that the 14th Amendment is very ironic. On the one hand, in the 20th century and into the 21st, it has been expanded to cover all sorts of people who were not on the minds of Congress. The gay marriage decision, most recently, a 14th Amendment decision. Now, people in 1866 were not thinking about gay marriage, but the principle of equal protection, there's nothing about race in the 14th Amendment. It applies to everybody. And in fact, the Equal Protection Clause is about persons, not citizens. It applies to aliens, too. And that they wanted to put that general principle into the Constitution, and it has expanded to cover, Ruth Bader Ginsburg pioneered using it to attack gender-based discrimination. Why not? That fits with the language of the 14th Amendment. But the irony is, in the last generation or two, the Supreme Court has sort of narrowed it when it comes to race. In every other area, it's been expanded. When it comes to race, they've become more and more, I don't know, to use a New York phrase, fetchy, about about, the 14th Amendment, equal protection, due process, etc. So, the 14th Amendment has greatly expanded the liberties of all Americans in significant ways. But on the question of race, it has never been used sufficiently. And that's what was mostly on the mind of the people who were thinking right in the aftermath of the Civil War and the end of slavery.
Professor, I guess the real question I have for you about the 3rd, 14th, and 15th Amendment is, I would view it as basically failures since they weren't able to reinforce the legal changes, and it took another major change in racial relations 100 years later with the 1964 civil rights. In a sense, that is what caused the change in terms of racial voting and allowing blacks to vote in the South. Because you had black codes, you had Jim Crowism. Well, the question is, I don't think there was a change that came about until 100 years later.
That's not a question, but it's an interesting
But
point.
I think in response that the change was due to social change.
Well, of course.
Not to political.
Constitutions do not enforce themselves, as he said. It required the greatest mass movement of the 20th century to bring about these changes. You're absolutely right about that. It's not just court decisions. It's not just political debates. It's people in the streets who bring about the fundamental change. Absolutely.
Right.
Really stepped in. There was that brief period where you had blacks in legislative positions. I mean, where these amendments, I think, actually were working. A relatively short period of time before the Supreme Court comes in and legislatures in white supremacy reasserts itself. So that I think there was success, but it was not success that was lasting. Get those 10,000 steps.
Exactly. In listening to all of you, I miss Abraham Lincoln. I feel like he's this country's greatest loss. And what I keep hearing in my mind are his words of a new birth of freedom. So, very quick story. I, by accident, hit Senator Ted Cruz on a flight recently. It was that by accident. And then I went up to him and I asked him why he won't support the 14th Amendment. I said, you know what it is. He, of course, said it's fine. I do. And at the end of it, I said, the only words I have for you are Lincoln's, that he, Mitch McConnell, and I think the Republican Party, that the judgments of the Lord are true and righteous altogether. And that makes what I want to ask you, is it that we have these 3 amendments that don't get enforced, don't get cited, Supreme Court doesn't overturn judgments that implemented them wrongly, because we haven't had the reckoning, that the bondsman hasn't been paid. And I'm wondering what we do about what Lincoln wanted us to do for Reconstruction, but he wasn't here to implement it.
Nobody knows what Lincoln would have done in Reconstruction. This is what we call counterfactual history, right? What would have happened if Lincoln had not been assassinated and Andrew Johnson had not become president? I don't mind speculating about that because nobody can prove I'm wrong. I think it's impossible to imagine. Johnson has a good claim, I think, to being the worst president in American history, although there are...
Not anymore.
Right. Yeah. Right. I was about to say there are other contenders, but Johnson lacked all of Lincoln's qualities of greatness. Johnson was a deep racist. He couldn't get along with Congress. He had no sense of Northern public opinion. He had no real roots in the Republican Party. It's impossible that Lincoln would have found himself in the fix Johnson did, getting impeached and almost removed from office. I think what would have happened would have been similar to what actually did happen up to a point. Lincoln and Congress actually knew how to work together. I think Lincoln would have he did support the 13th Amendment and helped get it through Congress. He would have, I think, supported the 14th Amendment. That was a mainstream Republican measure. Lincoln was a mainstream Republican. He was not a radical Republican. Would he have gone forward to supporting African American suffrage? I don't know. The further you go along, but the point is, as you say, go back and look at Lincoln's second inaugural address, where he kind of tries to get the country to think about the consequences of slavery. What he calls the 250 years of unrequited labor, unpaid labor. What are the obligations of the country for 250 years of unpaid labor? What about the violence? He says, we want the war to end, but God may want it to continue until every drop of blood drawn by the sword is paid by one. Every drop of blood drawn by the lash is paid by one drawn by the sword. In other words, he's reminding people violence did not begin in 1861. There's been 250 years of the violence of slavery. What are the consequences of that? What are the obligations of the society? Lincoln didn't live to to try to solve those questions, but he put them on the agenda, and we're still trying to figure them out today.
It's interesting because I think John Wilkes Booth really robbed us to see how the evolution of Lincoln might have continued. Because I think it's this book, or because remember he was talking about colonization, at one point, slaves freed and then being moved, back to Africa, and then black folks at the time saying, this is our country, we built this place, and he ultimately gets to the place where the Emancipation Proclamation and abandons the notion of colonization. It would have been interesting to see what Lincoln would have. I tend to agree with you that 13, 14 certainly, and I suspect 15 as well. I think.
I think that's a good place to finish this conversation. Thank you, Professor Foner. Thank you, Attorney General.
Can I say something? I would commend this book to you and the other writings of Professor Foner. We need to know more about our history. We need to know how history that has been taught to us is not necessarily accurate, though generally accepted. But at this time, in this nation's history, and given the situation in which we find ourselves, the conditions, the policies that we are dealing with, the president who we are confronting, the Republican Party that we are dealing with. This is really, I think, something that is more significant, more important than it otherwise might have been. To understand today, you need to, I think, understand yesterday. And this book, I think, is a very good guide to a very relevant American past. So I commend it to you all.
Thank you very much.